What's the proper role of citizen ballot initiatives compared to laws passed by the state legislature when it comes to making public policy?
Elections are the key. If you don't like whatever happens with a ballot initiative or with the legislative action or legislative action on a ballot initiative, you can express your ultimate power in choosing who represents you.
On this episode, we dive into the debate over Amendment D, which was a proposal to amend Utah's constitution, and we focus on the bigger constitutional questions that you're not hearing about in the press. You're listening to Defending Ideas. Defending Ideas is a weekly podcast produced by Sutherland Institute. On this show, we are committed to renewing the principles of common sense conservatism, making you a better champion of sound ideas. Welcome back to Defending Ideas. I'm your host, Nic Dunn, and this week we're talking about one of the ongoing policy debates in Utah right now about the Constitution and how laws and policy get made here in the Beehive State. If you've been following this, I'm sure there's a number of questions that are coming to mind for you, and if you haven't really been following it, you're in luck because we have a couple of experts that can help bring you up to speed and dive into some of the issues being debated right now. Coming back to the show are Derek Monson, our Chief Growth Officer here at Sutherland, and Bill Duncan, our Constitutional Law and Religious Freedom Fellow. Derek and Bill, thanks for coming back.
Glad to be here.
Thanks for having us.
So you two co-authored an op-ed in the Deseret News about this very issue, and I want to go through that and kind of help articulate some of the arguments that you make for our audience. But first, I wonder if you could just bring us up to speed. If someone hasn't been following it that closely, maybe kind of give us just the facts. What has happened in recent months that has kind of ushered in this big constitutional debate here in Utah? Kind of just give us a recap of where we've been. I don't know who wants to start, but...
So, a lot of this began in July when the Utah Supreme Court issued a ruling regarding a case about redistricting, and it was a law that was put in place by ballot initiative, and there was some reforms to that law, working with the proponents of the initiative, that changed it fairly significantly in some ways, and some of the folks behind the initiative objected how the legislature enacted or how those changes went. And so they sued, and in this ruling, the Supreme Court said that there was based on the history and what was in the Constitution, and then some kind of higher principles that they found outside the Constitution, that there was a reasonable expectation among people who run ballot initiatives that the legislature can't just come and just override the purpose of the ballot initiative and repeal it effectively. Unless they had some compelling state interest to do so, and did so in a very kind of focused, targeted, narrowly tailored way, which is kind of the highest legal standard that exists right now, pending new standards that get created by further courts. And so that led to the legislature deciding they didn't agree with that ruling. In practice, things haven't exactly operated that way, the way that the court said they should. And so they called an emergency session of the legislature, a special session, and enacted a constitutional amendment that would basically say that the legislature has the authority to repeal ballot initiative laws, just like any other law. Had a few other measures in it, but in context of what we're talking about today, that was the main thrust, and that created some opposition. A coalition called the Let Utah Vote Coalition was created to kind of oppose the amendment on the ballot, because every constitutional amendment has to be passed by a vote of the people, and that would have happened this November. And then various members of the Let Utah Vote Coalition decided to sue to stop Utahns voting on this constitutional amendment, and said that it shouldn't be counted. It should be invalidated, removed from the ballot, or just not counting the votes. And the District Court and then the Utah Supreme Court agreed with the plaintiffs in that case. So Amendment D will show up on your ballot this November, but no votes on it will be counted, because the argument was in that particular lawsuit was that the description of the constitutional amendment wasn't accurate, I guess, or was kind of misleading, is what their argument was, that it didn't capture what the purpose of the amendment was. And as well as it also was in violation of a requirement of the Utah Constitution that amendments be published in a newspaper 60 days before any election. The special session happened within 60 days of the election, And so they were arguing this wasn't following that rule of the Constitution. And the Supreme Court agreed on both of those counts. Although we have yet to be able to read their full opinion. They kind of rushed the ultimate decision so that we could know, and for the election purposes, what their ruling was going to be. But their full kind of fleshed out opinion is yet to be published. So that's what we know, and that's kind of where we are today. Bill, maybe.
No, I think that's right. You'll probably ask us some questions because some of the background behind that is really important. But yeah, I think that's right. Good.
Well, I think one of the questions is that even though this was initially started because of the dispute over the redistricting ballot initiative, the underlying issue really is not about redistricting, right? It's this kind of tees up these broader constitutional questions in Utah, and also broader questions about kind of what's the right way to make policy, essentially, between the legislature and citizens via ballot initiative. And so maybe, Bill, to get your thoughts on, can you help kind of lay the foundation for, now that the immediate, I guess, political disputes seem to be settled for now, as Derek described, what are the bigger questions that have not yet been resolved that we need to figure out as a state when it comes to the state constitution, how policy gets made?
Yeah, I think that the biggest question has to do with the role of the courts, and related to that, of course, is the nature of our Constitution. So when the Supreme Court ruled in July that the Utah legislature did not have the authority to amend a ballot initiative without court approval, I think many of us were surprised by that decision, recognizing that creates some challenges for key constitutional principles like separation of powers, as well as just the nature of a written constitution. If the terms of the Constitution govern, then a decision like the one that the court made is not. It's inconceivable, right? It's only when the court reads, like Derek described, kind of principles that it sort of thinks, the kind of the spirit of the law rather than the letter of the law, that you can get to that decision where the court then puts itself in the role of, every time the legislature wants to amend a law that was initially begun as a citizen ballot initiative, then the plaintiffs in the case just challenge the legislature's actions, and the Supreme Court has to decide, does this fit the spirit of what the voters intended and does it not? We have a system where, currently under the Constitution, we have a system where there's a very clear ways to reflect voter intention. That is, they select representatives who then pass laws, and can be removed if they don't accurately reflect the citizens' views, but then additionally they can also bring forward ideas. But there's nothing in the Constitution that suggests that the court needs to have a role to play in superintending what the legislature does. The Constitution gives to the legislature the legislative power, the power to make laws, and leaves for the courts only the responsibility to ensure that the written laws are applied as written, as understood at the time that they were enacted, and that's not intended to be an opening for the court to continue to invite new ideas in that are extraneous to the actual text and meaning of the Constitution.
Let's go to the op-ed that you two co-authored for Deseret News. It's called "Amendment D Decision Should Heighten Focus on the Most Important Constitutional Considerations." We'll include this in the show notes so each of you can read it, and I encourage you to do so because it's a thorough analysis, kind of springboarding from where we are today with kind of the resolution of the immediate debate, but then teeing up these broader questions that we essentially need to have a discussion around as a state to answer these. And I want to read an excerpt and ask you both to respond to it. In your opinion, Peace and Deseret, you both write, "In an August ruling on abortion and a separate decision in July on ballot initiatives, the Utah Supreme Court showed a concerning tendency in its legal thinking. Identify a principle absent from the text of the state constitution and use it to redefine the meaning of constitutional language." You go on to say, "A natural outcome of this approach has been to place the court in the role of resolving policy disputes, placing the court in a concerning conflict with the Constitution's principle of separation of powers." Can you expand on that a little bit? Why is this, in your view, kind of an example of this, where the court is maybe overstepping its bounds rather than being, engaging in decisions that are narrowly tailored and appropriately tailored to the text of the law or the Constitution. Why does this seem too expansive based on that purpose of a court?
Maybe the best way to answer that is to kind of refer people to something probably many are familiar with, and that's how a similar kind of thing happened at the U.S. Supreme Court. You probably remember that particularly from about the 60s to till very recently, the court often would, or at least the majority of the justices, would sort of read these principles in the Constitution that weren't there. But here's maybe a better way of saying this. You imagine someone brings a lawsuit and says, I have a right to do X thing. And, our natural inclination is, if we take seriously the Constitution, to say, well, let me look at the Constitution, see if that's there. I don't see that there. And the argument that some of the justices eventually accepted was, well, it doesn't mention, the right of assisted suicide or whatever the thing is. But but there's a kind of a principle behind the language of the Constitution, the right to define the meaning of life and the nature of liberty and all these kinds of things. And of course, it's extremely hard to tie down. Well, what does that precisely mean? If you're a citizen, if you're a legislator, how do you know whether what you're doing is going to be constitutional or not under that kind of analysis, where the courts identified some kind of meta principle that's behind the actual text? The value of the way the court has more recently ruled, where they've stepped away from that approach, is that although there will always be hard questions about the nature and the meaning of a specific provision, there is a way to find out what the meaning of a thing is. First of all, the text itself is going to often be very clear. And when it's not, there's a history of how that provision's been understood that informs the court's decision. When that happens, everyone has a pretty good sense of, okay, what exactly are the constraints on what we do? Now, I think what's important is that when the Supreme Court walked away from that, I think that they were giving a great example of how any constitutional that's not specific just to the U.S. Constitution. It's specific to any that applies to any written constitution. If we went to the effort to write those things down and to be bound by them, then we have to take very seriously what the law says, and we can't have a kind of the introduction of some alien ideas that the courts, make up, even if they seem like good policy, because in our constitutional system, the legislature is the one that considers policy decisions.
Derek, I want to get your thoughts. We got to go to break in a couple of minutes, but kind of building off of what Bill just articulated, is something you said, Bill, about whether something is in the text of the Constitution or if you kind of read into it ideas that are not necessarily there in the text. Using that as maybe an example in this case, Derek, is the Utah State Supreme Court kind of leaving judicial restraint behind in these instances? Is it becoming a little too activist?
Well, I think, it's hard to get into the minds of the justices, but I think that the rulings can fit the mold of being more activist in nature, at least when it comes to the ballot initiatives, right? This isn't a broad commentary. They've issued one case. There's I suppose, in the abortion ruling, like I mentioned in the op-ed, there some similar tendencies there, but it isn't like a years-long track record of this. So we don't want to, go too far in kind of declaring what's going on. But at least in these cases, so taking the ballot initiative case, I think on its surface they seem to be doing what Bill is describing, right? That there's language in the state constitution. It's not exactly very well defined. And so they took some of the language in different portions of the state constitution, including the language of the ballot initiative provision of the Constitution, as well as a different provision, and then said, okay, well, let's look at the history of the ballot initiative provision being enacted in the state constitution and find out what this is supposed to mean. But they did it in a way that was kind of meant to then justify and back up a certain set of ideas, in particular the idea that the legislature and the people are at odds with each other, and the former needs to be protected from the latter. The people need to be protected from the legislature. So it's but here's the thing: the reality is both of those things, the legislature and ballot initiatives, are expressions of the power of the people. The Supreme Court kind of talked about as if only one of those was an expression of the power of the people. Really, it was the ballot initiative. But the reality is, and Bill kind of highlighted this, electing representatives to pass laws is a right that you have. That's a power that you have as a voter, as a person in our constitutional system. And those things can live in harmony with each other. The right to legislate by direct vote and a ballot initiative, and the right to legislate through an elected representative. And the thing that ties those things together is elections. Ultimately, the check on all of this, if you don't like what the legislature does when it comes to ballot initiatives or non-ballot initiative laws, is you can kick them out. You can, through a primary or through a general election, vote someone else into office. And that should be the harmonizing thing. And getting back to the history issue, the state Supreme Court went back and looked at the history of the ballot initiative provision without looking at the broader history, which the Constitution was put in place, which was, and that goes all the way back to our U.S. Constitution, because a lot of the state Constitution borrows from that language and effectively incorporates that history and intent. And that constitutional history points to a real skepticism of the idea of people kind of legislating on their own. And that's why we have a representative democracy. That's the whole goal and purpose. Now, of course, we have the ballot initiative provision. And the purpose of that was to give an alternative way of legislating if the legislature was not doing what the people wanted. But the ultimate check on that isn't then for a court to come in and have to run in and save the day, save the weak people from the powerful legislature. No, these are all expressions of our rights as the power of the people. And we have the power to kick those people out of office if we don't like what they're doing. And so the Supreme Court, I think, kind of ignored that broader history. They looked at some of the history and set aside this other kind of part of the history to justify this idea that we have constitutional rights that are in conflict, and the people need to be protected from their folks that they elected. And that's how it became. It went from this thing that was a normal way of pursuing these things, looking at the history when things are a little bit ambiguous, to ignoring some of the history to inject an idea that really wasn't there to begin with. And now the courts are in the role of policymaker and having to rule on any ballot initiative that's going to come about.
We need to take a quick break, but when we come back, I want to explore that a little bit more, because there's this question of the balance. What is the appropriate balance between legislatively created laws and ballot initiative created laws? And I want to get into that because you touch on that in your op-ed. And also you mentioned some things that might be good sort of guiding principles for moving forward. How do we as a state sort of resolve this bigger constitutional debate in a way that's constructive, so that we can still be, the best managed state with great upward mobility and well-crafted public policy. So I want to get into all that and answer some additional questions about this big debate over Amendment D and Utah's Constitution more broadly. So we're going to take a super fast break. Stick around. We're talking with Bill Duncan and Derek Monson. This is Defending Ideas. We'll be right back.
For a deeper dive into the issues you care about, read Sutherland Institute's official blog, Insights and Takeaways. You'll gain deep insights from policy experts and relevant takeaways voters need to know. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. I'm Nic Dunn, and we're going to continue our conversation about Amendment D and Utah's public discussion over the Constitution and how policy gets made. Before we jump back in, though, I want to remind you, if you like what you're hearing today, please visit defendingideas.org. You can find access to this and previous conversations, as well as short clips, and you can access the various podcast platforms where you can subscribe to Defending Ideas, like Apple Podcasts, Spotify, YouTube, wherever you like to watch or listen to your shows. Just search for Defending Ideas and click subscribe. And if you're watching on YouTube, make sure you click the little bell icon in the corner so you get reminded each time a new episode publishes, which is every Tuesday morning. Again, all that and more at defendingideas.org. Well, Bill and Derek, I want to jump back in because there are really kind of two key takeaways from your op-ed as I saw it. That you argue, one, the sort of the court maybe becoming more activist in these specific decisions that you referenced. And you addressed that a minute ago, but also this broader question of the proper role of ballot initiatives. And so I want to start there to maybe give our audience some framing principles, some ideas that can help shape this conversation moving forward. And I'll just maybe try and approach it as sort of a regular voter skeptic saying, well, what's wrong with ballot initiatives being able to stand even if the legislature doesn't like it? Why is that not a good thing for those ballot initiatives to have that additional level of protection?
Well, I think a few key framing principles from our Constitution are that the ballot initiative is a power of the people to legislate directly. You also have in the Constitution the power of the people to legislate through an elected representative, which is what our representative democracy is all about. So we have this ballot initiative process, and it's in place in the instance where someone or the legislature is not doing what the people think they should do. They should have another option to directly legislate. It's kind of a product of the progressive era of the early 1900s. A lot of states in the United States do not have these provisions. That's something to keep in mind. It's we were talking about it during the break, and I can't remember if it's half and half or close to half and half. But the point is, there's a good chunk of the people of the United States that don't have access to a ballot initiative process. So it's not this kind of embedded right across the country, is what I'm saying. And in that system, the ballot initiative process, that right to legislate directly, should fit within the broader constitutional system, which is about representative democracy. And I think we said this earlier, but I think it bears repeating that what that means is elections are the key. If you don't like whatever happens with a ballot initiative or with the legislative action or legislative action on a ballot initiative, you can express your ultimate power in choosing who represents you. And this is one of the concerning things about the ruling of the Supreme Court back in July. In some sense, it actually kind of undermines our system of elections, because while the court maybe didn't state this, the kind of unstated presumption is that the voters are in a position of weakness and must be protected from their elected representatives by the court in this case. But that's only true if our elections don't function, right? If the elections function, then there's no need for courts to step in at all. And so that is kind of what is, again, being kind of the outside idea being projected and put into our constitutional system is that our elections are there as the check, but maybe in the minds of the justices, not really that effective. And in fact, so much questioning that we as the kind of unelected body needs to come in and be the protectors. And when you look at the frames, you look at the Federalist Papers, in our national constitutional system, which our state constitution is based on, it was clear that they saw elections as being the muscular check on anything an elected person would or could do. And it's kind of concerning that the court hasn't recognized that when it comes to ballot initiatives.
Bill, is that right? Is it kind of the elections are an anchoring, if not the anchoring mechanism by which I as a voter make my will known, and we shouldn't do anything to sort of pull back from that principle?
I think that's right. One of the things that's interesting to think about is that other states, of course, have approaches to ballot initiatives as well. And one of those, of course, is California. And California has come up in this debate a little bit because there's some concern that we not do things that California has done related to ballot initiatives. But one of the things that's interesting about the ballot initiative process in California is that if voters propose an initiative, it gets the requisite signatures, goes to the election and is passed, it can't be amended without another vote of the people. And so that's actually structurally required. The Supreme Court decision here in Utah did something similar, only it injected the court in the kind of the guardian decision of whether or not the legislature is acting appropriately. But I think it's important that we didn't include that. And that suggests to me that the Utah legislature wanted to allow a safety valve, to allow voters to draw the attention to their concerns, but not to do that in a way that sort of does away with the representative system, which allows for some filtering of ideas, waiting for a little bit of time. Maybe something seems like a really important issue right at the moment, but we need a little more time to think about it, a little deliberation. California's system doesn't really allow for that. Utah's system, as it was created under our Constitution, does allow for that. The legislature can say, "Hey, well, look, that was an idea that the voters brought forward. It's not working in this situation. Circumstances have changed, whatever, and we need to adjust that." Now, under this court decision, unless the court steps away from this approach, we now have an even more complicated system where the voters come up with an idea, that they can't convince the legislature to go along with. Then they get a ballot initiative passed. The legislature says, well, gosh, this isn't working, or maybe this wasn't wise, or this was kind of a fad for a little while. We'd like to step back, but then the Supreme Court has to say, well, actually your amendments, the changes you want to adopt, are inconsistent with the kind of a free floating spirit of the initiative, and so you can't do it. That was not the intention, and I think it's important to note, if that was the intention, they could have done what California did. They chose not to. And so I think that's an important, maybe just a little distinction that's worth noting as well.
In the few minutes that we have left, I want to read two more excerpts, and then kind of my final question is going to be, what's next? What do we do as a state to create the right framework where we can make policy in the best way, given this sort of current debate we've been in? And I want to read these two excerpts, and maybe, Derek, start with you to respond to each of these as we start to wrap up. You both write in your Deseret piece, the primary impact of this limit in the court's July ruling is to make the court the final word on the fate of every policy reform enacted by voters and significantly reformed by lawmakers, placing themselves squarely between voters' direct legislative power and the voters' power to legislate via those they elect to legislate. And then as you're kind of concluding your piece, talking about, well, given this sort of predicament we're in now, here's some ideas for moving forward. And you write, if Utahns are forced to live under ballot initiatives that are difficult to repeal, then the vetting process for such proposals ought to be thorough and deliberative, similar in nature to the heightened deliberation inherent in representative democracy. So it sounds like you both are kind of giving us a path forward to say that, well, there's this core principle in the American experiment in Utah that was drawn from those principles in the U.S. founding of representative democracy. It's deliberative in nature. Can you expand a little bit on how does that idea sort of give us the framework moving forward to help answer this question in the coming months and years?
Well, I think that really what we're talking about here is, in the ballot initiative process, there are inherent flaws and weaknesses, just like there are in any other process. So how do we incorporate the best of representative democracy to improve and kind of leaven the loaf, as it were, of the ballot initiative process? So if we did things, for example, I mean, there's a number of ideas, ways of doing this. A number of years ago, I wrote an op-ed. It was published, I believe, in the Ogden Standard Examiner, where we suggested the idea that perhaps ballot initiatives ought to require not just a majority of total state votes across the state, but maybe they ought to require a majority in geographical districts. So think like how the legislature works. You have to get a majority of state senators, a majority of members of the House of Representatives who represent different areas of the state. Well, why can't we do that with ballot initiatives? So that you have to say within Senate districts of the state of Utah, win a majority in a majority of those districts for a ballot initiative to pass. You're not making it more difficult than it would be under the legislature. It's the same kind of guiding principle. But what it requires is more deliberation in the creation of a ballot initiative to be geographically resonant, not just resonant to where the population center is. Another way of doing this would simply be to lengthen the process a little bit. You know, most pieces of legislation can take 3 or 4 years to pass because they get refined, and this is a process of deliberation, like Bill mentioned. Well, you could require ballot initiatives to get enough signatures to get on the ballot, and then not put them on the ballot for a few years. Give people time to study them. Some really thorough analysis, by organizations that do things like Sutherland Institute or university institutes, to kind of analyze what the impacts of this would be, so that when we do have to vote on it, it's better informed, it's more thoroughly considered, and maybe even there ought to be a place for lawmakers or even a citizen kind of body to look at the language of a ballot initiative after it's gotten the signatures requisite to be on the ballot, to refine it a little bit before it ever gets to the ballot, to make sure that some of these concerns, about constitutional questions, or is it the right thing to do, can be refined and figured out before voters vote on it, and having to kind of make a difficult choice of a language that might not be great.
Excellent ideas to start the discussion that we'll have, I'm sure, as a state for weeks, months, maybe years moving forward on this. Bill, we'll give you the final word. How do we imbue into this policy creation process that we have before us now the principles of representative democracy in a better way?
Well, I think the way you ask the question is probably points to the answer, and that is first we have to identify why did the framers create a system of both the Utah Constitution and the federal Constitution that prioritized having representatives act on behalf of voters to make wise decisions. The kinds of things we've been talking about, some time to deliberate, to really think about things, injecting a little time frame. We come up with an idea because we get upset about something, but then a little while later it disappears, and I'm glad we didn't do anything. Some of those kinds of factors are exactly the types of things we need to re-inject into this process. And so identifying them, recognizing the wisdom of the framers in creating the system that they did, and not just having a kind of national referendum on every single concept that ever comes out. Once we identify those principles, we can then appropriately inject them into our system, and we can preserve, if the voters want to do that, we can preserve a ballot initiative system, but one that's not burdened by all the weaknesses of our current system, and that of course then frees the court from feeling like it has any particular responsibility to inject itself in to superintend the system because they're afraid maybe it won't go well.
Well, we will have to leave it there, and I'm sure we'll be talking about this in an ongoing way because constitutional law and policymaking is very important to Utahns and to us here at Sutherland. But thank you both again, Bill Duncan and Derek Monson, for being with us on Defending Ideas.
Glad to be here.
Thanks, Nick.
We're going to take one more quick break before we leave you with some final talking points. Stick around. You're listening to Defending Ideas. We'll be right back.
Sometimes it's hard to keep up with the latest policy debate that affects your life. The solution? Subscribe to Sutherland Institute's weekly newsletter, where you'll find in-depth insights from seasoned policy experts, compelling multimedia, and advance notice of special events. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. Before we go, there are two things that stood out to me from our discussion today. So here's an approach that I think we can use to help us understand or discuss this topic. First, whenever we find ourselves in a debate that has anything to do with the Constitution, state or federal, it's easy and normal to take the approach of asking which positions sound reasonable to me from a policy or political standpoint. But I think that's actually the wrong approach. Instead, the first question we should always ask is, what in the text of the Constitution can help answer the policy question before us? Starting with what the Constitution says is always an important first step. And when it comes to this debate over Amendment D and Utah's Constitution more broadly, an important principle that's not getting enough attention in the public discussion is the virtue of representative democracy. It's what the American idea is built on, and as Bill and Derek articulated today, bringing this principle to bear on the current debate over how policy gets made in Utah will help lead us in the right direction. That'll do it for this episode of Defending Ideas. If you enjoyed this discussion, please visit defendingideas.org. You can access previous episodes and watch or listen on your favorite platforms. Don't forget to subscribe to Defending Ideas on Apple Podcasts, Spotify, YouTube, or wherever you get your shows. Just please make sure you share this episode on your own social media profiles or with friends, family members, or coworkers who you think might find it interesting. Lastly, if you want to support the broad work of Sutherland Institute, if you want more conversations like this, please make a contribution at sutherlandinstitute.org/donate. Thanks for joining us for Defending Ideas from the Sutherland Institute in Salt Lake City. I'm Nic Dunn. We'll see you next time.